Time is yielded back. Mr. Tierney, I believe, was next.
Thank you, Mr. Chairman. Mr. Chairman, I think it's time to recap a little here. And so I just want to acknowledge that what we're talking about here is a complaint, not a decision of any judicial body. This is a complaint that has made allegations, and a complaint that, if the allegations are proved, suggests a remedy. All right. The administrative law judge hasn't yet decided the facts, hasn't fashioned a remedy, and here we are as the Congress attempting to interfere with that adjudicative process. So I guess it falls into the adage of, thou dost protest too much. Maybe our friends on the other side are just so certain that the violation exists that they just sort of preempt where they're going. The National Labor Relations Board says very clearly that it's unlawful to retaliate against workers for engaging in protected activity, and striking is one protected activity. So apparently our colleagues no longer believe that that should be protected, and that should just be allowed to be dealt away. Counsel alleges a specific violation, says the company made coercive statements. There's apparently a strong record of that. One, as I mentioned before, my colleagues must think is right on the money and going to be successful. It threatened workers for engaging in the statutorily protected activity of striking. This is legislative interference with an adjudicative process. This isn't some elected board getting in there and interfering with a company. This is our interference with the adjudicative process, which ought to be seen as offensive to everybody on both sides of this dais. The Act clearly provides that the board can order such affirmative action as will effectuate the policies of the Act. And the Supreme Court has found that relief is to be adapted to the situation which calls for redress. It's up to that adjudicative process to decide what the appropriate remedy is. Now, I know a lot of people, including our chairman in his opening statement and others over here, have listed off some of the prospective remedies that otherwise exist other than the one they're most fearful of. Well, those aren't adequate, I don't believe. But the adjudicative process will decide whether they are or not. And if they decide that they're not adequate, they will fashion a relief, and it could go up to and include the relief that was requested by special counsel in the complaint. In fact, that kind of a request for situations like the one we're dealing with is pretty standard as a remedy. In 2000, a Los Angeles federal district judge imposed an injunction prohibiting a jewelry company from moving to Mexico after the workers there had successfully organized. The National Labor Relations Board secured an order that restored to California's facility the work that had been contracted out. It returned to California the facility equipment, fixtures, and supplies, and the work that was contracted out, reinstated the employees, and rescinded any other outstanding agreements because it felt that the law had been violated and this was the only effective remedy. Mr. Chairman, I request unanimous consent to enter into the record a copy of the United States District Court, Central District Court of California's order granting preliminary injunction in Aguilar Ray NLRB versus Quadtech Corporation, November 21, 2000.
Without objection.
Thank you. In this case, the one we're dealing with here, Boeing is fighting to relocate jobs to a non-unionized, lower-wage work area in South Carolina. Now, you all say, well, one of the remedies they have is those people in Washington, they go to South Carolina. Is it a remedy to leave a higher-paying job with all the rights of belonging to a union to move to a lower-paying job without any rights and protections of a union? It earned record profits, Boeing did, in 2010. It tripled its income from the previous year from $1.2 billion to $3.3 billion, much of that paid for by the American taxpayer. People like those that work for Boeing and made Boeing productive and then paid their taxes to see this company, because of its officers, because of its board of directors, move to another company to further enhance their position. The fact of the matter is that today's unemployment isn't caused by unionization. I mean, unions in the private sector only constitute 8% of the workforce. When the unions were at their highest level, we saw more productivity and better wage growth. As they've declined, wage growth has declined, and income disparities have been surmounting and increasing. In fact, in 2009, that's the date that people give for the start of our recovery here, to the end of 2002, national income rose $528 billion. But you know what? The employers got $464 billion of that, and working people got $7 billion in wages and salary. That's a shame, and that's disparate, and that should be unacceptable. What is government here for if it's not to stand up for the individuals? If you think it's a populist notion that you're going to fight for multinational corporations to beat up on the little guy and the families and the small businesses that thrive on them, take it to the public and tell them what a populist you are. Populism and the role of government is to stand up for the people, Stand up so they don't lose their job. Stand up so they can make a decent wage. Stand up so they can share the productivity and the prosperity of these large corporations that will beat them up to enhance their bonuses and their executive salaries. And then tell them your remedy is to move from one part of the country to another part of the country where people don't unionize, where they don't stand up for their rights, where they don't fight for more wages and a decent part or share of the pie. In 1991, when that economic recovery started and the income in this country went up, half of that income went to the working men and women. Half of it. Not $464 billion to the CEOs and the board of directors and $7 billion to the people that are working and pushing hard to make that company productive and to make this country productive. When and if the facts are proven in this case, a remedy should be fashioned that's appropriate and that's effective. That's
The gentleman's time has expired.
Before I completely run out of time, I would like to yield the rest of my time to Mr. Tierney.
Thank you very much. Look, the question here isn't whether or not companies can make business decisions and have those considerations. It's whether or not people on both sides of the aisle think that a company should be allowed to relocate work in retaliation for employees exercising a statutorily protected right. If not, if you don't agree that they should be able to violate an employee's statutory rights, then do you agree that the remedy should be make them whole, should fashion a remedy that really is effective, stopping companies from doing it in the future and putting the workers back in a position where they can be best served on that? That's what the California case did, and Mr. Goodlatte has left, but he indicated that, you know, in Mexico they had to do that. Then in Mexico they had already made the investment in Mexico. They had set up shop. They had transferred the work out there. They had put equipment and things of that nature there, and the court found that that was the only remedy that could happen, is to bring it all back and make those workers whole. So the people in South Carolina may be happy now when Boeing decides, if it's found that in retaliation they're going to move to South Carolina. But if, again, someday they retaliate because people in South Carolina want to unionize and bring the jobs to Mexico or to China, we'll see what the posture is at that point in time, whether we'll stand up for the workers there or think that it's all great about chasing profits and we'll stand up for the corporation.
The gentleman's time has expired.
Ask unanimous consent for one additional moment.
Without objection.
Thank you. You know, standard of living was mentioned, and I think that's a good point to make. But in 1991, with that particular recovery, at that point in time when profits were made, one half of those profits went to wages and salaries. And most recently, at the end of 2009 into 2010, as things were supposed to be recovering, $464 billion of profits went to profits, and $7 billion went to wages and salaries. That's a reduction in the standard of living. That's what people that work in this country are experiencing, and that's why it's important. That's a direct result. It correlates directly with a lack of unionization, a decreasing unions, and increasing movements of companies to ununionized states where the wages are lower and to countries where the wages are lower as well. So I think those are considerations that we can make. I think it's important to do that, and I hope that people will consider that in making their determination. And thank you, Mr. Chairman. Well, I appreciate that, although I think we're probably pretty close to all talked out here on this. And I think the points have been made. I appreciate the Chamber of Commerce advertisement that my colleague just gave. And maybe we can take the next round by each of us giving a statement for our own respective region, and that'll take up even more time. But no, I think this really does come down to an issue here of whether or not we think that the rights of people that work for a living are worth protecting every bit as much as large corporations and their shareholders and their executives on that. And Mr. Kelly, I didn't want to beat a point to death on that, but I thought it was rather unusual that you thought that your rights needed protecting from your franchisor, so that you wanted to deprive that company from deciding where its franchisees would be, which ones be open, which ones be closed. But then again, you saw a distinction for standing up for employees who are watching their jobs be relocated in retaliation, ostensibly, if that's proven, in retaliation for simply wanting to organize to go for better benefits, work conditions, and salaries. And I call back again the notion that I guess we can all have a race to the bottom. We can all decide that we're going to support any given locality to go for the lowest paying jobs with the least pushback on any employer, to let the employer do whatever they want to do, pay whatever they want to pay, put whatever conditions they want to put on there in order to get the jobs. But that goes back again to our issue of what's the quality of life And we have watched, I think, if you go to most people in this country that are working for a living, they will tell you that their wages, if they have any, have been pretty stagnant for a long time now. And that's because they're not sharing in the national pie. That productivity goes up. There's much more income than there was before, yet it's no longer divided even close to 50-50. It's very disparate. When the numbers are $464 billion to $7 billion, I think that should all make us sit up and realize that something's wrong here, because that $7 billion in wages and salaries, that's what's going to buy your car. There aren't going to be as many people lined up to buy your car. You might sell a few Cadillacs, you know, to the folks at the top of the chain, but those thousands of people who normally
will the gentleman yield?
Certainly will.
I don't mind people making a decision not to buy for me as long as the government doesn't make that decision for them and put you out of business.
So you didn't mind the franchisor shutting you down. That's why you sued to get it back. That's my point on that. And these people do mind a company coming in and shutting them down, and now they're just trying to get their rights exercised. So I think that's, you know, Mr. Andrews makes it right. That's the difference here. We think that people should have the government that protects their rights, to make sure that when they have something that's statutorily protected, they can actually go out and enforce it, and that it's meaningful. And that when the National Labor Relations Board looks at a case and says, you know, this is worth litigating because we have enough evidence, we think, to bring this before a judge and let the judge decide, then they have somebody standing up to this huge corporation that otherwise would just go out and make a decision. For us to then come in and say, you know what, we don't trust the adjudicatory position, but we're going to all put it on, we don't trust the NLRB. The NLRB is doing its job. It has made a determination. I think there's enough evidence there to bring for a judicial body to make a determination. But apparently the people on the other side of the aisle don't trust the adjudicatory process. They're not willing to let those decisions be made for the evidence to either be conclusive or not. And then they're not willing to have that particular adjudicatory process decide what the right remedy is that should be fashioned to give people the full benefit of their rights on that. And I think that if a court would come down, as they did in the California case, that they cannot be fully brought back to the status quo ante, can't be made whole without having things move back, then that's something that we should acknowledge, and it should be done, and we should stand behind it. Because as I said earlier, there is going to be that day, in all likelihood, where it's possible that somebody's going to look at a South Carolina business or some other business and say, you know what, we don't want that employee even having a voice in what's going on, and because you tried to have a voice in what's going on, we're going to some other country because we can pay people what we want to pay them. We don't have to obey environmental rights, safety rights in the workforce, or any of those other things over that. And that's, you know, what we have. We have to have a better monetary policy, better trade policy, better job training policy. All of those things are going to bring manufacturing and other jobs back to this country, but they need to be done collectively. They need to be done all at once. And standing up just saying, well, you know, the employer's rights are paramount no matter what they decide to do and how they decide to trample on people's statutory rights, I don't think that's the answer. You folks may, and I guess that's the debate. I yield back.